Hi, YouTube. Okay, so I have a few more documents to share with you for educational purposes in regards to our appeal case at the federal level in St. Louis, Missouri. It is September 21st right now, and we still have not gotten a final decision on this, just so you know. So we've had a little bit of downtime to enjoy our chickens and our dog and get some things ready for winter. So here is one thing that I wanted to show you was our reply. Now remember, we did a reply brief and then they sent their reply, and this was our last reply. Okay, so we sent it to Julia Kelly, the representative counsel for defendants, Morrison County Sheriff's Department, et al. And so there is the first part of the paperwork. And you can get all of these forms online, okay? Okay, just our signature page. Trying to do this outside, so okay. There's a certificate of compliance with type volume limit that is required to include with your reply, with your legal brief and reply. This one was 3,259 words. Okay, this was our table of authorities, the different cases and the page numbers, the statutes, codes, and laws, and the table of contents, opening statement, motion to strike Appley's brief and void Blackwell's dismissal, procedural errors occurred, and conclusion. Okay, this is the front page on appeals, reply brief of appellants. That is us. We are pro se. Okay. Opening statement. The council's concluding statement in Appley's brief, page 6. This appeal should be dismissed because it is frivolous, must be denied, an entire brief stricken based on filings in fact and law. In this reply brief, we will explain how we have documented in multiple filings to prove beyond a preponderance of evidence that our case is not frivolous, has merit, and states a claim. We prove that defendants and U.S. District Court Judge Jerry Blackwell are out of compliance with federal rules of civil procedure, rules of appellate procedure, and the Model Code of Judicial Conduct, of which 8th Circuit Court of Appeals must take notice and grant default with all relief sought in complaint. We have submitted documents in timely fashions with explicit detail to describe our case and have been treated as less than human when our rights are continually violated. Laws and rules are twisted to benefit the defendants, simply to protect them because they are a government entity. The right to petition is one of the fundamental freedoms of all Americans and is documented in the First Amendment to the Constitution of the United States. We are victims suffering from harm done to us, so the courts must recognize. Motion to strike Appley's brief and void Blackwell's dismissal. Under Rule 12F, a party of a pleading can be removed if it is redundant, immaterial, impertinent, or scandalous. A lapse, omission, or breach in the consistency of the process causes unfair advantage or disadvantage, resulting in harm and prejudice to the plaintiffs, preventing an impartial or proper hearing. Ms. Kelly's and Judge Blackwell's procedural errors materially prejudice the findings and outcome. Judge Blackwell's judgment of dismissal must be vacated. The defendant's brief stricken and base appeal only on appellant's brief and this reply brief. Procedural errors occurred. Appellee's brief is redundant. Counsel for defendants repeat the word frivolous 9 times in a 6-page brief at 1, 2, 1, 2, 5, and 6. Appellee's brief repeat the word disability 10 times at 1, 1, 3, 4, and 5. The redundancy of terms used attempting to dismiss a claim is disgraceful and in bad faith. 2. Appellee's brief, page 1. Commenced action January 23, 2023. On 1/18/2023, defendants refused service and directed process server to Julia Kelly of Iverson Roovers. However, Kelly did not file notice of appearance for the defendants until May 2, 2023 in federal court. Defendants were without counsel from 1/23/23 through 5/2/23. Kelly did not file any notice of appearance in appeals court to this date. Entry of appearance for represented parties. B. Within 14 days after a new case is docketed, counsel must file an entry of appearance. For counsel retained after the case is docketed, counsel must file an entry of appearance within 14 days after being retained or admitted to the Federal Circuit's bar. See Federal Circuit Rule 47-3B1C. Counsel must use Federal Circuit Form 8A PDF to enter and to modify an appearance. See Federal Circuit Rule 47-3B6. Counsel for defendants is out of compliance. An entire brief must be stricken. Number 3. 4/3/23. Court issued summons for 19 defendants. Document 15. All 19 defendants were served on 4/18/23. Sheriff Sean Larson is authorizing agent accepted legal papers for 19 defendants, and we have video proof of that. Answers were due by defendants 5/9/23, document 17. Counsel Kelly gave notice of appearance for 12 defendants, 5/2/23, document 18. 7 defendants have not retained counsel or replied to complaint and summons. The following 7 defendants have not appeared or responded and must be held in contempt of court for failure to appear. Brad Bordwell, Jason T. Brown, Eric Hannikin, Calvin Cheetah, Daniel Owens, David Callis, and all other law enforcement on scene 8/24/2020. Coincidentally, Eric Hannikin's name appeared on the appeals court denial for request for transcripts. That was odd. All the inconsistencies point towards guilt and liability. Defendant's counsel attempts to gaslight us by avoiding the matter, confusing the courts, and uses false statements to pin mistakes on us. Yet it is clear that the errors made throughout the court case are errors made by the counsel and the court. Number 4. Counsel for defendants and courts identify defendants differently in legal documents. Defendants are named 5 ways in 3 courts. See request for transcripts, 5/24/23 at 9. Kelly named 12 defendants on cover page of brief, but signs last page, counsel for Morrison County, appellees. This states she is representing Morrison County as a whole. Kelly's numerous mistakes pointed out, in addition to not filing notice of appearance in appeals court, result in a document that is not legal and must be stricken from the record. Number 5. Defendants falsely base the requested dismissal on Blackwell's first judgment 5/5/2023, document 19, but omits Blackwell's subsequent order issued 6/5/2023, document 26. Their appeal is not frivolous, as the U.S. Supreme Court has defined that term. Counsel is nefarious in intentionally omitting documents. Blackwell's first judgment, 5/5/23, was void when he issued 2 more orders afterwards. 5/9/23, coincidentally the same day defendants' answers were due, and 6-5-23, order reversing the decisions on frivolousness and informa pauperis. Number 6, defendant's brief, page 1. However, on May 5th, 2023, Blackwell granted appellant's IPF notice applications. First, defendants make an error in labeling IPF incorrectly. Error is made twice on page I and page 2. If informa pauperis was one of their main arguments, misspelling the abbreviation is frivolous in itself. Defendant's counsel is supposed to be professional, yet they cannot proofread a legal document for spelling errors. Secondly, defendants are wrong in their statement. Blackwell's judgment on 5/5/2023, document 19, states, denies the IFP applications. Blackwell's order on 6/5/23, document 26, plaintiffs' IFP applications are granted. We were not granted IFP status by Blackwell until 6/5/23 order. However, the court recognized filing of suit to proceed by issuing summons on 4/3/23. Again, defendants omit Blackwell's 6/5/23 order in bad faith. Congress's goal in enacting the informa pauperis statute assures equality of consideration for all litigants. To conflate these standards would deny indigent plaintiffs the practical protections. To dismiss a case based on frivolousness because plaintiffs qualify for informa pauperis is denying our protected constitutional right to redress government and a violation of our Fourth Amendment due process and equal protection rights. Therefore, our case must not be dismissed by the defendants or on Judge Blackwell's decisions. 7. Appellee's brief, page 5, footnote 1. Appellants are simply mistaken, and the order indicates this matter came before the district court on several filings by plaintiffs, and not at a hearing or trial. See Order R, Doc 19 at 2. This statement is false. Document 19 states, this matter is before the court on several filings. However, Blackwell's corrected judgment, 5/9/23, document 21, shows the box checked decision by court with highlighted text for emphasis. This action came to trial or hearing before the court. The issues have been tried or heard, and a decision has been rendered. Blackwell's original decision was corrected to indicate there was a hearing or trial that occurred, although the plaintiffs were not notified as required by Federal Rules of Civil Procedure and Minnesota Statute Chapter 13D, Open Meeting Law. Counsel for defendants intentionally omit this document. Blackwell acted as the defendant's counsel and held a hearing or trial without our notice, knowledge, or consent. His actions are unethical, unconstitutional, and sporadic at best. Number 8, Appellee's brief, page 3. However, to state an ADA claim under 42 U.S.C. 12132, a plaintiff must allege 1. That he/she is a qualified individual with a disability. Nothing in the disability discrimination claim related to ACR. The appeal brief is not a reply to the claims stated in the complaint. Therefore, this is a non-issue. Appeals court is tasked with reviewing a lower court decision to determine if there were error in or misapplication of law, abuse of discretion, procedural problems, or constitutional violations. Attorney Kelly discusses the ADA claim in the complaint. Appellee's brief, page 3. Logreen, on the other hand, alleges law enforcement dispatch incorrectly advised officers he had violent Asperger's disease because he does not have this disability. See R. Doc 1 at 10. Logreen then fails to allege he has any other disability or that he was subjected to discrimination based on a disability. This is a procedural problem. Defendants had their chance to defend the claim prior to May 9, 2023, and failed to do so. Therefore, the question of disability or claim of discrimination against the Sheriff's Department is immaterial and moot. Evidence of these topics would have been submitted during the discovery phase if the case would have gone to trial. We demand a jury trial in original, amended complaints, Document 1, and other memorandums, having been denied this right with no explanation. To appease appeals court, Michael's disabilities can be proven with a preponderance of evidence at this time. That is, 1. Michael receives a disability check from the state of Minnesota, which was documented in confidential application for informal paperas. 2. Michael completed confidential ADA accommodations form in state court, acknowledged by Morrison County ADA Coordinator Kim Peterson, Judge Mary Mahler, and Minnesota Council on Disability. Executive Director David Fenley. 3. Judge Mary Mahler addresses Michael's accommodations by announcing his specific disabilities, breaching data privacy laws, creating bias in open court to the defendant's counsel and all present, including the Morrison County Sheriff's Deputy Bailiff, December 21st, 2022. Number 4, Judge Mary Mahler allowed some, but not all, accommodations, be that they were discriminatory and not accommodating, in court for Michael's disability at hearing on February 22nd, 2023. And 5, Judge Gail T. Kulik accepted previous judges' approval of accommodations in court and allowed accommodations for hearing on June 30th, 2023. Michael has disabilities. Again, proof of Acker's or Logren's disabilities is moot. Any claims of discrimination in the judicial system is a separate issue and will be dealt with through formal grievances, complaints to the judicial board, and future lawsuits. It is not to be confused with the matter at hand. Number 9. In Trest v. Kane, 522 U.S. 87, 1987. Trest pointed out that the Fifth Circuit had raised and decided the procedural default question sua sponte, and that language in the court's opinion suggested that it had thought that once it had noticed the possibility of a procedural default, it was required to raise the matter on its own. We filed for default in state court, and default hearings were scheduled 3 times. After complaint and relief was filed in federal court, 1/23/23, Document 1, default was entered 3/20/23, Documents 7 through 10. Motion for default was not heard, and no decision was made. Summons was issued to 10 defendants, 3/22/23, Document 11. When again the court's error was identified by plaintiffs, us, and corrected by the court to include all 19 defendants, which then amended summons was issued for 3/23. Plaintiffs executed summons in federal court April 18th, 2023, and the court issued answers due by May 9th, 2023. Document 17. Plaintiffs again motioned for default and relief in federal court 5/12/23. Defendants nor their counsel replied in answer. They did not deny or defend any of our claims in the complaint. Appeals court must raise the matter of Federal Rules of Civil Procedure 55 default on its own. 10. Appellee's brief, page 2. The court shall dismiss the case at any time if the court determines the action is frivolous or malicious, or if it fails to state a claim. Blackwell Document 19, 5/5/23, page 9. When determining if a complaint states a claim on which a court may grant relief, a district court accepts the complaint's factual allegations as true and draws all reasonable inferences in the plaintiff's favor. The failure of the defendants to read and reply to our claim does not indicate it is not a claim. To reiterate to the courts and the defendants that we do have a claim, we quote from our complaint, Document 1-23-23, one example, not in entirety. Beginning May 2019 through present day and including incident August 24th, 2020, Morrison County Sheriff's Department, abbreviated to MCSD for efficiency, did, under color of law, violate Minnesota state statutes, state policies, county ordinances, regulations, or customs, willfully subjecting plaintiffs to deprivation of rights, privileges, or immunities secured or protected by the Constitution or laws of the United States. Plaintiffs claim the defendants violated the following state and federal laws under color of law: deprivation of constitutional rights, 18 U.S.C. 242, conspiring against plaintiffs' constitutional rights, 18 U.S.C. 241, 42 U.S.C. 1983 Civil Rights Act, and Americans with Disabilities Act of 1990, Title II, 12131, 13132, and 13132 was repeated, I guess. 1. Morrison County Sheriff's Department violated authorized use of force, Minnesota Statute 609.06, Subdivision 3. Limitations on the use of certain restraints. Force was used by a public officer in assisting officers under the direction of a public officer. Sheriff Larson, Sergeant Gross, former Deputy McDonald, Chief Eric Hennigan, Officer Cheetah, and Trooper Owens. Illegal chokeholds performed on Michael while handcuffed and on squad cam. Officers McDonald and Trooper applied pressure to Michael's neck, throat, and windpipe, hindering breathing, reducing intake of air, and attempting to stop the flow of blood via the carotid arteries. There is no threat of death or great bodily harm that would authorize this use of deadly force. Michael stated he could not breathe. Michael feared for his life. Witnesses attest if they were not present, Michael would not be alive today. Defendants do not deny that they used illegal chokeholds according to Minnesota law. That in turn violated Michael's constitutional due process rights when he was already in custody. The claims we make are not frivolous. The harm caused by the violation of our rights is serious and affects our daily lives. This claim became fact when defendants did not answer complaint and summons May 9, 2023. Number 11. Appellee's brief, page 5. Appellants claim that the district court acted as counsel for defendants. However, nothing in the record supports appellant's claim here. Blackwell acted as defendant's attorney when he filed the judgment 5 days before the defendant's answers were due, using a signature move of smoke jumping, as he admitted to doing as a former attorney in State v. Chauvin case 27 CR 2012646. See Plaintiff's Appeal 5-2423L at 6. Blackwell gained fame as the attorney who offered the state's opening statement and closing argument in the case that ultimately saw a jury convict Chauvin on murder and manslaughter charges. Yet he defends Morrison County. We believe if we were black, we would have been taken more seriously. Blackwell, at 6N, made arguments for two defendants, David Callis and Rick Madison. It is the responsibility of the defendants to reply to the complaint or counsel to argue defense for the defendants. Blackwell responding for the defendants is a violation of the Model Code of Judicial Conduct. See Disqualification Rule 2.11, 5, and 2.3, Bias, Prejudice, and Harassment. Upon appeal, Rick Madison's name is now listed as a defendant, but David Callis's is not. Blackwell also held an illegal hearing or trial without notice or knowledge. Documents 21. Defendants and counsel continually disrespect court orders and federal rules of procedure. In Campaign Legal Center et al. versus FEC 192336 or 21-5081 22-5336. A dismissal was contrary to law. The court further stated that there was ample evidence of coordination that the commission failed to consider, illustrating that the dismissal was arbitrary and capricious. Because the commission's decision was based on impermissible interpretation of FECA and was otherwise arbitrary and capricious, the court granted the plaintiff's motion. Blackwell's premature dismissals are arbitrary and capricious. I'm not even sure if I'm saying that word correctly, so forgive me if I'm wrong in pronouncing that. As stated in May v. Thompson, 67 P. 2D, 1109, 1110, Utah, 1984. A court's ruling must be based on adequate findings of fact and the law. Conclusion. This is a serious matter. The defendants are making a mockery of the judicial system, and we have lost all faith in the judicial system. The courts are biased and discriminatory. See memorandum, request for transcripts, appellant's brief filed, and note conversations, phone conversations. We are punctual and concise when providing information and notification to the courts and the defendants. The defendants are contumacious, insubordinate, defiant, and non-compliant, neglecting professional responsibilities in attempt to avoid accountability. We have offered to settle this matter outside the courts, to expedite procedures and save both parties and taxpayers unnecessary expenses, but defendants are unwilling. Out-of-court settlements are the most efficient way to solve a dispute. Avoid the risk of unfavorable verdict from a jury or judge and reputational damage. Settlement was a quicker, easier route the defendants could have taken, but that time has passed. A later, full hearing in state court does not cure the problem in either case. As the court recognized in Gibson, a subsequent de novo hearing cannot undo the interim harm to constitutional rights. Moore v. Sims. We don't want this case to continue, but if the courts decide otherwise, we will not retract. We want this case to end immediately, with due compensation for us for the years of physical, mental, emotional, and financial stress endured, and disciplinary action for the defendant's wrongdoings to prove that there is some justice in the world. Regardless of the results of this appeal, the world will hear about our case. We do audits and podcasts with other auditors from Maryland to California, exercising our First Amendment rights and uncovering corrupt government officials on our YouTube channel. We have hundreds of videos, thousands of subscribers, and millions of views from all over the world. Every single person, every single Minnesotan deserves to feel safe and protected in their communities. This law is the first step toward major change to hold police officers accountable for harmful acts. Governor Tim Walz, Minnesota Police Accountability Act 2020. The law included a ban on warrior training and chokeholds. It requires the duty to intercede and report the use of excessive force by fellow police officers. These laws were not in place when George Floyd was murdered by Derek Chauvin. These laws were in place when Michael O'Green was choked. For the above 11 reasons, including all the filings, and in the interest of justice, strike the defendant's brief from the record, vacate Judge Blackwell's previous decisions as void, and grant default with all relief immediately to prevent further harm. We pray for justice and peace in this matter. No justice, no peace. That was our reply brief. We hope it made a difference. The other documents that I will be showing you in the next couple of videos is we requested transcripts. They said the appeals court said that we could request transcripts. So we did at the government's expense, which they said, and then the state court accepted or allowed one of the transcripts, but not the other 4. So we're still going through some paperwork with that, and submitted a correspondence to the appeals court and to to the administrative office of administrative's hearing court also. So I will talk about that in my next videos, but for now I am signing off and leave you with a cute picture of our puppy. Thanks for watching. Please like and subscribe. Take care.